They're sitting there looking at Lindsay in a wheelchair as a defendant in a criminal trial accused of murdering her children. They're the people next door. They're the people who are in everybody's neighborhood. They're the people that your kids go to preschool with, or your kids go to school with, or your kids play soccer or baseball with. This is not a woman who, was torturing animals as a child. This was you. Every woman sitting on that jury with a family, this is you. And as a result, this isn't about whether or not she's the one who killed the kids, but why? Did she do it intentionally, or was this really a really unfortunate circumstance that arose out of her severe mental health problems?
Day one of Lindsay Clancy's murder trial kicked off on Monday, where her defense plans to argue that she was not criminally responsible for murdering her 3 children on the night of January 24th, 2023, because she was suffering from postpartum psychosis. The trial began with opening statements from both the prosecution and the defense, and a testimony from Patrick Clancy, Lindsay's ex-husband. As the U.S. Sun continues to follow this case, we're joined by Utah-based criminal defense lawyer Skye Lazaro, who will break down everything that's happened so far. Be sure to like and subscribe to stay up to date on this story and much more. Could you start off by briefly explaining a little bit about what opening statements are in a trial? Are they used as evidence? Are they not? Is this something typically seen in trials?
We see opening statements in almost every trial. The state or the defense or one party can waive their opening statements, but I think that's really rare. The reason is the opening statement is both the prosecutor and the defense attorney's first chance to explain to the jury, this is why we're here. It's not evidence. They're instructed by the judge that nothing that's said in opening statements is evidence, but it allows attorneys to be able to tell a story. This is where we want you to go, and plead some passion into it. Try to get the jury thinking about your client, or for the state, what the state needs to prove. The opening statements in this case, I thought, were pretty typical from the prosecution side. Usually what we see the prosecutors do is sort of march through the evidence, say, this is what we expect to show you over the course of the week. We're going to prove to you that we charged her, we were right. She planned this, she did it deliberately to murder the children. And they really did that. There wasn't a lot of passion in it, but they did kind of walk through a roadmap, so to say, of what they were going to show the jury in the coming weeks. The defense in this case, I thought, actually did a far better job. He really implored some passion into it, and he used a lot of what we call demonstrative exhibits. Those exhibits are not evidence. But they can be used to tell the story. So he used pictures, he used graphs, he set up the history of this family, how they'd been trying to get mental health help, and really the system failed them. And as a result, this isn't about whether or not she's the one who killed the kids, but why? Did she do it intentionally? Or was this really a really unfortunate circumstance that arose out of her severe mental health problems?
I want to get into some of those stark differences between the prosecution and the defense, especially, the defense attorney bringing in images, especially, graphic and gruesome ones. But I wanted to start off first with talking a little bit about the prosecution. They opened up their statements talking about Lindsay Clancy's 3 children, Cora, Dawson, and Callan. Can you tell me a little bit about that choice to start off with kind of sharing memories of them? They talked about how Dawson, was full of energy. Could you tell me a little bit about that choice?
Trials really are theatrical. I know they're very real and they have very real consequences, and they're about people's lives. But most jurors don't have a lot of experience with the justice system or trials. What they see is what they see on TV. So when you give an opening statement, or you're trying to communicate to the jury things to really get them on your side. So starting out talking about the children is to really get the jury thinking, these kids were real human beings. They humanized them in a very, very effective way, talked about the kind of kids they were, so that people in their minds can create a visual. So as they're listening to the evidence, they're thinking, this is a real person. They're not thinking objectively somebody died or it's a thing. They're thinking about this kid who was boisterous, or this kid who played or smiled or loved to color. All of those types of things make it very real in a jury's mind. So when they're considering evidence and considering what the state is trying to prove and the arguments being made, in the back of their mind, they're thinking these poor three little kids. That's really what the state was getting at in describing those children as is making them real from the very beginning.
Could you tell me a little bit more about the impact those sort of descriptions have on the courtroom? I mean, as those statements were coming out, Lindsay, appeared to be crying in her wheelchair. She seemed very upset. Are these statements made to cause a reaction, or is it mainly just to, set the stage of these are real people that this happened to?
It's both. One, you want to set the stage that these are real people, but you want to elicit emotion from the jurors, whether it's sympathy or disdain for the defendant or whatever those emotions are. And really, the jury is also judging everybody from the second they walk in, including the defendant. And so when she's sitting there crying as they're talking about their children, that probably helps her. If she's sitting there making weird faces or acting like she doesn't care, we've talked about this in a lot of different cases about the way defendants react and their facial expressions and how harmful or helpful that can be. But really, talking about those children and creating a picture about them for the entire courtroom really sets the tone for the trial and elicits emotion, makes them very real people. And this happened to these innocent children. These are the kinds of cases for jurors when you have children who are the victims, are very easy to get jurors to be sympathetic, to elicit emotion really from everyone in the courtroom. I've been in trials where court clerks have gotten emotional at times listening to testimony.
And now Lindsay is facing 3 murder charges, and this whole case is kind of revolving around the fact of, is she criminally responsible for the deaths of her children? Do you think we could break down a little bit about what the prosecution is arguing in her case?
Yeah, this case absolutely turns on not whether or not she killed the children, but whether or not she had the legal mental intent to kill the children. So what the prosecution is attempting to prove and what they laid out in their opening statement is that she was very aware of what she was doing. She planned this. She set the stage early in the day. She went to the pharmacy or talked to the child's doctor. She sent her husband on errands. She sent him to pick up dinner from somewhere that was a little bit further away and really planned that so that she would have the opportunity while he was gone to kill the children, and then, as she did, attempt to kill herself. And really, that's what the state has to prove. There's multiple elements to every crime. But one of the ones that's very, very important is this mental state element. And that's whether somebody intentionally and purposely does something. Some crimes have a negligence element to it. But what the state has to prove here is that she intentionally and purposely murdered her children. She killed her children. She planned to kill her children. She intended to do it. And so without that, the defense is probably going to prevail in this case. If the state's not able to establish that.
And as you mentioned, they are trying to prove that this was an intentional killing. And, there's been some interesting word choices from the prosecution in their opening statements. I mean, they said, quote, like deliberately strangled her children. And one of the other ones that stuck out to me was, they said she coldly and efficiently executed them. What can you tell me about this word choice and how that plays into their argument?
The term deliberately is actually a legal term that we see in definitions. So with regard to mental state, if you deliberately do something, or you intentionally or purposely do something, these other phrases about the execution, I think really go more to trying to implore upon the jury just how depraved this act was, that this was not just she was out of her mind in a psychosis, that she purposely planned to execute her children or to murder her children. And so I think using strong word choices, while prosecutors have to be careful so they don't get themselves in a place that's objectionable or perhaps is problematic and can come back on appeal, we'll see them use stronger words to convey what the jury is going to continue to hear throughout the trial, which is this intentional, deliberate, purposeful, planned, because all of those words are going to show up in jury instructions at the end of the case when they go back to deliberate.
And the root of this case is obviously involving Lindsay's mental health and her struggles with it. And one of the arguments that the prosecution had set up was that she actually had a lot of access to mental health services, you know. What can you tell me a little bit about that argument that they're setting up and what we might expect to see as a trial goes on with that argument?
It doesn't appear that anybody disagrees that she didn't have access to services. In fact, she had been actively on her own and with the help of her husband and her family getting and seeking treatment. She'd done an inpatient stint. She was seeing doctors. She was changing medications as prescribed, doing all of those types of things. I think that argument for the state may backfire just a little bit. When we talk about mental health, you have to be careful. You can't necessarily blame someone for their mental health when they're trying to get help. You know, that very well could be either a failure on the part of the medical system, or it could be just it's a process to get stable sometimes, and it's a process to find the right medications. And she was doing that and doing everything that she could. And I think that actually is more harmful to the prosecution than it is helpful. I don't know that blaming someone for not doing enough when they were trying to do everything that they can, at least from the defense's perspective. She wasn't ignoring it. She wasn't saying, oh, I'm fine. I don't need to go to the doctor. She was actively trying to get help. And her husband was very aware of it. And it sounds like they talked about it quite a bit. So I think that may backfire on the prosecution. You get the wrong jury, and people are going to be a little turned off, I think, by blaming someone for not being able to control their mental health problems. I mean, that's why they seek professional help, is because they aren't able to manage it on their own.
And I want to move over now to the defense's opening remarks. You know, Lindsay's attorney, Kevin Reddington, he started out by telling the jury, you know, usually we would thank you for your service being here. But he had said, like, he kind of issued more of a warning to them. He said that they were going to listen to and see, quote, the most horrific things. And he told them, you people will never forget this case. You know, what kind of significance does that opening have as a defense attorney?
I think that immediately gets people on the edge of their seats. There's a couple things you want to do as an effective defense attorney in trial. You want to take the sting out of things that are not helpful to you. Because if you say them first, you can kind of pass them off a little bit, like we're aware of that, but it's okay. If the state says it first and blindsides you and says, well, the defense didn't want you to hear that, you know, that can be harmful. The other thing is setting them up for, you're going to hear and see things you wish you could unsee. And you have to remember, you know, I have the utmost respect, and I think every trial attorney does, for jurors. These are people going about their normal everyday lives. We pull them in off the street and tell them, hey, you guys get to sit and listen to some really hard facts. You know, some of these cases include pictures and testimony and statements of things that are horrific, that most people don't want to listen to. Most people don't even want to see on TV. And they have to sit there and be the captive audience and ultimately make a decision at the end of that trial. And that is a very high burden that we just place on everyday people. And so I think in him doing that, I think, one, it acknowledges just that. Look, we understand that you're not here by choice. We understand that there are some things that you are never going to be able to unsee for the rest of your life. And unfortunately, that's part of the deal. But I think it conveys, one, a level of respect to the jury. And the second thing I think it does is it really gets people listening, because as humans, we're intrigued by catastrophe a lot of times. And when you start there, and say, look, this, you will remember this for the rest of your life. Uh, it kind of does something to us psychologically where we're like, okay, well, I really want to listen now. I want to hear what's going on, even though I may not actually want to see it or hear it.
Prosecution had said, it was heartbreaking, and he had said like a little bit more of like more kind of detailed responses. So I was curious if you think like his words were more effective at getting across to the jury of, respecting what the work that they're doing and also just like highlighting how gruesome it could get.
Anytime you can invoke passion, which I think he did a very good job of doing, I think it's far more effective. Your job is to tell a story. Your job is to tell your client's story. You're at the end of it, you're asking the jury to believe you, to find for your client and against the state. And so when you communicate that way in a way that tells the story, it naturally draws us in. Using words and passion the way he used them, I think conveys that he believes this is very real. He understands the gravity of this. He understands how serious this is. He respects the jurors' time. He respects the fact that they are going to have to sit and listen to this. The flip side of that was the prosecution's, it's a little cold or a little removed from the situation where they're just marching through the evidence. Yes, it is heartbreaking. I think we can all agree this is a very heartbreaking tragedy. But conveying that in a way that evokes people's feelings and connects with people is always far more effective. And that's the purpose of opening statements. You want to, one, give the jury a roadmap, but really what you want to do is you want to connect with them. You want them to want to listen to you. You want them to want to listen to your witnesses and your experts because you are so invested in this case. You believe in your client's innocence and you understand what they're going through as well.
I feel like we got a bit of insight into her lawyer's, style. And, very early into his opening remarks, he called out the local district attorney in the courtroom. He physically pointed to him, said him in the first row, and, called him out for bringing these charges against Lindsay Clancy. What do you think of that, of him taking a second there to bring attention to him?
I've seen that done very effectively in a number of cases where really what you're saying to the jury is, I'm sorry that you have to listen to all of this. I'm sorry that you got drug out of your lives and away from your families so you can get paid $18 a day or whatever it is that we pay them to sit there. But don't blame us. Blame them. They're the ones who brought the charges. They're the ones who are the reason that you're sitting here. My client is a poor, mentally ill, damaged woman who needs help. She didn't commit a crime. Or she didn't intentionally murder her children. And what he's saying is everything you're going to hear, jury, over the next couple of weeks, that man sitting there already knew. He knew before he filed this case. He's learned probably more since then, and yet he is still the reason that you were called in here for jury duty and you're going to have to listen to it. And I think that sets the tone for the jury because they're going to start thinking a little more skeptically, like, if all of this information was known and they believe it, why are we here? Because you don't want them to ever blame the defendant for exercising their constitutional rights to a trial because they've been accused. I mean, she's facing life without the possibility of parole potentially. So she's going to go to trial. But you don't want them to blame the defendant for sitting there. You want that responsibility to be on the state because they're the ones who filed the charges. They're the ones who pursued the case and didn't dismiss it, didn't give her a deal that was workable, didn't let her go to the state hospital, whatever it was that we're sitting here today, that rests solely on the district attorney's shoulders.
I want to dive in now to a little bit of like the main points that her attorney mentioned in his opening statements. He started talking about Patrick and Lindsay's relationship. He said they had it all. He talked about their humble house. What can you tell me about that choice to bring up their relationship and marriage and, the life beforehand?
I think it's brilliant. The reason is they're sitting there looking at Lindsay in a wheelchair. as a defendant in a criminal trial accused of murdering her children. Him telling the story of this is who these people are, they're the people next door. They're the people who are in everybody's neighborhood. They're the people that your kids go to preschool with, or your kids go to school with, or your kids play soccer or baseball with. This was a normal, loving family. And, they're educated, they had good jobs, they had a great relationship. Everything was normal, everything was okay until she began suffering from this postpartum depression and psychosis. And what that does is it sort of lays the explanation, it lays the bedrock for where they're going with this entire trial is this is not a woman who's been crazy her whole life. This is not a woman who, was torturing animals as a child. This was you. Every woman sitting on that jury with the family, this is you. Except that she had this unfortunate circumstance of developing or suffering from postpartum depression and psychosis after her child. And then, he went on to explain all the things that they had done to try to get a handle on it. And really, I mean, it's sympathy, it's understanding. If any woman on there had ever struggled after having a child or knew someone who did, that's very real to them, because then you start thinking, oh my gosh, this could be me. This could be me sitting in that chair if things went bad or things got out of control, and no matter what I did, I couldn't get a handle on it. I think he did a very good job of that, and I think that's going to live in the jurors' minds for the remainder of this trial.
And as you mentioned earlier in his opening statements, he brought pictures for the court to see, and they were graphic images. They showed the injuries that Lindsay sustained to her wrists and her neck, and there was an image of a bloody knife on the counter. It was next to, like a coffee mug kind of thing that said, "Because kids." And he said, pills were found crushed in that. He really showed the jury what the scene was like. He even showed blood on the floor. Can you tell me about why he would choose to show photos during his opening statements, and especially because the prosecution didn't?
As I mentioned before, anytime as the defense you can acknowledge all the bad facts before the prosecution can, you take the wind out of their sails. You take the sting out of it, because they're going to probably see those pictures or similar pictures throughout the course of the trial. But they're going to say, hey, we've already seen these. They kind of lose their effect in some ways, because the defense attorney showed them to us. He's not afraid of them. He understands what happened that day. In fact, he's the one who told us first about what that scene looked like. And so as the prosecution now marches through their case and shows these pictures and has forensic analysts get up and talk about them, or investigators get up and talk about them and what they observed, or her husband talking about it, it really diminishes their impact for the prosecution, because they're still going to be thinking, yeah, we already know this. He already told us this. The defense already told us this. We knew it. It's not about this. We know that this happened. It's about whether or not she was really sick, whether or not that is the reason that she committed these offenses, that she couldn't form of the mental state, that she couldn't purposely and knowingly do it because she was so sick she couldn't appreciate her own actions. That's the purpose for doing that. And I think any good trial lawyer who gets up and does that really does themselves and their clients a favor throughout the remainder of the trial.
And you already kind of mentioned it earlier of thinking one side had a bit of a stronger opening than the other, but having gone through all these details now, can you tell me who you think had the stronger opening statements?
I still think the defense did. I think they did a far better job of really telling a story, getting the jurors thinking about not just what happened, but why it happened, instead of just marching through the evidence will show you this and the evidence will show you that, almost like they're a little detached from it. And I think the defense did a far better job of setting the framework for the remainder of this trial, and really did a good job of placing the burden, which it should be, but solely on the state, because you never want to get in a situation in your openings where you feel like you have to prove something. It really is the state has to prove it. We already know it. They already know everything. They have to prove it. And if they don't prove it, you blame them.
And after the opening statements, we then got into the first witness in the trial, which is Patrick Clancy, Lindsay's now ex-husband. It was kind of interesting to see that he was going to be the first one in when he walked in. It kind of almost felt like the courtroom had chills. Lindsay looked a little bit worried, a little unsettled in her wheelchair. And, with a list of over 200 witnesses in this trial, what difference does it make for him to be the first witness?
That's always a strategic decision, I think, when you think about the witnesses you're going to put on, especially for the prosecution. Putting him on first, I think they're going to tell a story. What I gather from this is they're going to tell a story in chronological order. So they put him on first to lay the framework, the background story about them, about the children, about what he observed that day, what happened that day, and set forth. And then they're probably going to go into the crime scene and probably finish with their experts, I would expect. But it's always a strategic decision as to how you want to lay your trial out. I think you want to start with a strong witness and you want to end with a strong witness. The stuff in the middle you want them to listen to, but you want to capture their attention to begin with. And when you are finished, before the defense gets up, now the state gets to put on rebuttal witnesses if they so choose, because it is their burden of proof. But you want to finish on a strong witness as well, so that the jury maybe is thinking a little more skeptical about the defense when they start talking.
What kind of impact do you think, from what we heard in Patrick's testimony, that it had in the courtroom and on the jury?
Man, that poor man is in a really, really awful spot. I thought he testified well. He's clearly very intelligent. He's very articulate. He's very believable. I really felt like he just got up and told the truth. And I think that will land well with jurors. And, a lot of what he said yesterday was as helpful for Lindsay as, maybe it was for the prosecution. I thought he did a good job of handling the prosecution when they would rephrase in a different way what he just said, and trying to make it sound a little worse, or make it sound like she was more intentional, because really that's what they're trying to get to with all these questions, is she knew what she was doing. There's no question she didn't know what she was doing. And if they can establish that she knew what she was doing early in the day, then why in this just 20 minutes would she all of a sudden not know what she's doing? But he did a good job of handling that. They kind of rephrase something and he'd say, no, it was more like this. And so I thought he did a very good job. He's like I said, he's clearly very educated. He's very articulate. He speaks very well. And I really just feel like he's in the most horrible position ever. I know he said previously he would testify for both the state and the defense. But I think he just, got up there and told him about really the sad state of where things got with Lindsay and all the things that they did to, try to get a handle on it.
I'm kind of curious about, the order of the questions that were asked. Obviously, when they began, they asked him, who he was, where he worked, if he was married to Lindsay. And they kind of started off by asking about how him and Lindsay met and to, describe the births of their children. Could you tell me why they would start off with that instead of going just straight into, what happened in the months before?
There's a couple reasons you want to do that. One, you want the jurors to know who this person is. You want the jurors to believe the things that he's going to say. So talking about people and who they are, that's what we do in conversation. When you meet someone, hi, how are you? What do you do? Do you have kids? Tell me about your kids. Maybe we don't go into the depth that they went into in his life, but that's a very normal conversation starter. So it does a couple of things. One, it gets jurors, or it gets jurors understanding who he is, kind of understanding the framework of this family, a little bit about their background, that he is smart, he's educated, he went to college, has a good job, is kind of the person next door, all of those types of things, so that he's believable. The other thing it does for your witness is those are easy questions. When you start by doing that, you get people a little more comfortable talking, because being up in that witness stand is a pretty lonely place. You're up there all by yourself. Everybody's staring at you. People are asking you questions that you probably don't want to be there talking about. And so it can be very, very intimidating, and a lot of people can clam up. There's a lot of witnesses, doesn't matter how much you prepare them. If you don't get them talking first, they'll get up there and they'll give you one word answers. How was your home life? Good. What do you do for work? And they'll give you one word answers over and over. And you really need to get more than that, especially when you start talking about what happened that day, what happened at a scene, what they observed. You want them to be able to describe it. So warming them up by talking about those types of things usually helps them testify a little better as well.
It almost kind of seemed later in his testimony that he was giving more of those short one-word answers. But do you think that was just because of the questions that the prosecution was asking? I mean, towards the end of it, they started showing videos and photos of the family trips they took in the couple of days before their children died. And, they would ask questions of like, is that Cora going down the slide? Did Lindsay go down the slide with Cora? And it almost sounded like a frustrated, like, yes, no, going back and forth. Could you tell me a little bit about that? Was that just because of the kind of questions they were asking, or does that, maybe happen as the testimony goes on?
I think it's a couple things. One, the emotional toll, I think, as this testimony progressed, and then to talk about the kids and the trips that they took I can't even imagine. I'm a parent, but I cannot imagine what it must be like to have to sit up there and answer those questions and relive the good moments with them, and the bad. And so from an emotional standpoint, I think everybody responds to that a little bit differently. And it really takes a toll on people. So I can't imagine what he's going through. The other thing is the structure of the questions really didn't elicit more of an answer. When you say, is that so-and-so, the answer is yes or no. It's not, tell me about this picture. What was happening? What were you doing? Instead, they really just asked them to elicit yes and no answers.
And, with all that evidence that was being shown of them, having these trips right beforehand, what was the prosecution trying to set up with this? Because even so, there with some of their questions, they would ask, how was her demeanor? And he'd just say, good. I was hopeful it was getting better. What were they trying to set up as an argument here by showing videos of them at a water park and asking him questions about going to a museum?
Really, what the state has to prove in this case is that she acted knowingly and intentionally, that she knew exactly what she was doing, that this was not a mental health break, that this was not a product of her psychosis, that she had the capacity and the ability to make a plan, know what she was doing, and appreciate the consequences of it. It's a two-part test. And so in asking questions in the times leading up to it, even when perhaps she was suffering from this postpartum depression, what they're trying to show is she is present. She does know what's going on. She can make decisions. She can interact with the kids. She's normal. And so this defense of this postpartum psychosis is a complete farce. It's made up. Really is what they're getting at, is it's not real. That's not what happened. She's using it as an excuse right now to get away with the fact that she murdered her kids because they were driving her crazy, or she didn't want to be a mom, or she couldn't handle it, or whatever it was. But she intentionally killed those children. And so asking questions, not about that, but about all the other things in her life that she did make decisions that she knew about. She was present. She did know what was going on. She did appear to be completely with it and have fun and know where she was at and know what everybody was doing and who everybody was, and didn't have any problems functioning. So that's really the purpose of those. You ask those kind of easy things about trips, about birthday parties, about day-to-day stuff where she was home with the kids, she was taking care of them, she was doing all of these things that requires somebody to have it together to do, at least from a mental standpoint. And really what they're laying out is, and I would expect that they'll argue down the road, is this psychosis wasn't real. And I expect that we'll probably hear competing expert testimonies in this case. And the states is probably going to say that this isn't what happened with her, this is now just a convenient defense for her to say, and maybe she did have some problems, but they weren't that bad.
Do you have any predictions of what we could see next? Is there anything you think that viewers tuning into this should expect from the rest of his testimony or from the rest of the trial?
They may call other witnesses who were around her in those prior to, while she was suffering from postpartum, to elicit similar testimony. You know, she went to coffee with you, she had this discussion, she drove there, she knew what she was doing. You know, all of those types of things that we all take for granted, but they really need to hone in on to show that this was not a psychotic break. This was not a product of postpartum depression. And we've learned from other trials in the past that this is an effective defense and is a very real mental health problem if it's not treated and managed correctly. So, and they'll probably try to put some of the blame back on her. Did she take her medication as prescribed? Are you aware that they did get into some of those questions with him to show that, even if it was a break, she caused it because she wasn't doing what she was supposed to. So I would expect we're going to continue to see a similar style as it relates to him and probably other witnesses.
Do you have any predictions for what the defense will be like as the trial goes on?
I would expect, you don't usually see a lot of objections raised unless things are clearly out of bounds. I think the defense signaled in their opening statement, hey, we already know all this. We know what was found at the crime scene. We know what it looked like. We're going to see those pictures again, and we're not worried about it. So I would not expect to see a lot from the defense. I think they're just going to, like I said, unless it gets out of bounds and there's something that they need to raise, I don't expect to hear a lot from them as the state puts on their case. I think they'll just let them do it. Because the thing is, if you object, one, you have to preserve it. So if there is an issue, you do have to object or you can't raise that on appeal. But the downside to objecting is you signal to the jury, I didn't want you to hear that, right? And then it lives in their brain forever. So I don't expect we're going to see a lot from them as the state puts on their case. And then they're going to say, okay, great, that was your theory. And then they're going to present all of the information that they want out there. I don't think we're going to see them dive into disproving the state's theory. I think they're going to say, whatever, like we already knew that. I already told you that in my opening. But let me tell you what was really going on with this woman. And let me tell you how real postpartum psychosis is. And let me tell you how it really works and why she could not appreciate what she was doing and, why essentially you should find her not guilty by reason of insanity.
Well, thank you so much, Skye, for offering all of this insight on the Lindsay Clancy trial. We greatly appreciate you joining us.
Thanks for having me.